Even though both the Supreme Court and this court have explicitly held that such challenges are not within the power of the federal courts to hear. The district court's order is therefore appealable, much as a TRO directing the president to redeploy a carrier group from the South China Sea to the Persian Gulf, or to halt.
Hang on. I mean, one of the claims pressed here, which the Supreme Court has expressly said, and we have said, courts can entertain, but put aside interpretive questions about whether there's an incursion or invasion, is whether these individuals qualify under the terms of the proclamation, whether they're members of Tren de Aragua. I assume, as below, the government does not dispute that that is something courts can adjudicate, correct?
Your Honor, it's certainly something that courts have adjudicated in individual habeas claims.
That's a separate thing, but courts can do that. And so asserting a power to do that is not ordering ships to relocate in foreign waters, right? That is straight up judicial process that's allowed by the Supreme Court and circuit precedent. I understand you have your argument there about habeas, right? But that's a procedural point. Your points about him overstepping seem to be forgetting that there is this claim, and in fact, this morning, he's limited the TROs to the likelihood of success to that prong. And so we don't need to go any further than that, correct?
No, I don't believe so, Your Honor. Because the government has taken appeals of the TRO, the district court didn't have jurisdiction to change the basis of the TRO. And so because...
That was one of the bases all along.
I disagree, Your Honor. The bases of that order were set forth on page 41 of the transcript from the Saturday hearing, and they were expressly limited to just those second guessing of the president's determinations the statutory preconditions of the AEA had been satisfied.
Okay, if we read the record differently, if we read it to include these claims having been pressed from the beginning and including at the hearing, it's insane from their complaint that their clients, at least the ones that we have, the named plaintiffs and some of the other ones, are not members of Tren de Aragua and had no chance to demonstrate that when they were rushed onto airplanes and flown to El Salvador, or at risk of being rushed onto airplanes and flown out of the country. And so if we read the record that way, then we don't have to get into these other questions, correct?
No, I don't believe so, Your Honor. And
No, we don't have to, or no, I'm wrong?
I guess I would say several things, Your Honor. One is that the district court's order goes well beyond merely preserving the status quo. It purports, as the district court explained, to order the president to conduct operations outside U.S. borders in a particular way. He directed that the executive branch either turn planes around or to find another way to operate internationally.
Right, but so, I mean, at this point, my understanding is that the government has been complying with the TRO. Obviously, it doesn't extend to people who are being deported on grounds independent of the proclamation. So when I say complying, that there are no planes now en route out of the country with people covered by the TRO, correct?
That's my understanding, yes.
No planes on the ground anywhere in the world with people covered by the TRO that would have to come back.
And Your Honor, let me just first clarify.
Is that factually right?
I believe so, Your Honor, though. Let me clarify one thing about that, which is that the district court's order only applies to those that would be removed under the Alien Enemies Act.
Correct.
It does not apply to those that may separately have final orders removed under the INA.
Yes, that's right. I'm sorry I wasn't clear. I was trying to say that up front. If there are other grounds for moving them out of the country, he was quite clear, was clear again this morning, but it's been clear from the beginning that's never been enjoined under the temporary restraining orders.
That's correct, Your Honor.
Right, so we're not talking about those. So you might have planes with people going other places because they've got ordinary orders of deportation.
I think that's right, and I apologize, Your Honor. I think we're agreeing. And
I was clearly me not being clear enough. So clearly me not being clear. So now to clarify again, my question is the concern about ordering planes back and forth is moot at this point. That's over and done. There's nothing we could do to address that. Nothing we could do to remedy that, even if we were to agree that that shouldn't have happened. That's a question, but it's just moot at this point.
I don't believe so, Your Honor. I think the district court understands the government to be under a continuing obligation, having not turned the planes around to return the people, find some other way to return the people. I don't think the district court has interpreted its TRO as no longer being operative. And so I think that continuing aspect of it supports appellate jurisdiction here.
You read it as requiring the return of people who are no longer in U.S. custody?
Your Honor, the government does not believe that the oral pronouncements as opposed to the written one is binding, but as the district court appears to have a different view, his oral order provided for two ways of compliance, either turning around the planes or finding a way to return the people to the United States. The first option is no longer available, but the district court has not said that the second option is not, is not still in force.
And much of this, I think, has to do with the compliance issues that are, I think, separate and go forward regardless of what happens with TROs. And so, as of right now, your concern is that if the TROs, I don't know, for your sake, say even the written TRO, so the written version of the second TRO is in place, what language in that requires the retrieval of people from U.S. custody?
Your Honor, I think
let me clarify again, that are no longer in U.S. custody?
Your Honor, it's not that it would not be the written order. I believe it's on page 43 of the Saturday transcript. It was an oral directive, but more broadly too, this is a nationwide TRO that enjoins the president from using any of his AEA authority to remove people during this period. Okay. That is something.
But that's different. That's not ordering ships around in the water. And that's not ordering planes to go anywhere. All that the TRO, the nationwide TRO says is folks that are detained and folks can still be detained under the AEA. They just cannot be removed from the country until this point, until I guess you get a preliminary injunction decision from the court, which looks to be forthcoming soon.
I agree that the district court looks like it may be acting on a preliminary injunction soon, but I think the intrusion upon the war powers and foreign policy powers of the president is utterly unprecedented. And in a way...
Well, this is an unprecedented action as well. So, of course, there's no precedent for it because no president has ever used this statute this way, which isn't to say one way or the other what it can be done, but simply to say we are in unprecedented territory. But I'm just trying to really clarify here, if you agree that, and I believe you agreed in district court, I think you agreed here, but tell me if I'm mishearing, that these folks have a right under the AEA, under precedent, to challenge their status as individuals subject to, they fall within the terms of the proclamation here. That is, I think most relevantly, whether they are members of Trinidad, although maybe they deny Venezuelan citizen status too, I don't know. But the big one that seems to be in the papers is, they said we're not even members of this. In fact, some of us are fleeing from Trinidad. Is it your position that a temporary restraining order that simply prevents removal until there's procedure and opportunity in place to address whether they even fall under the proclamation? Are you arguing that that is an unwarranted intrusion on the president's powers?
Yes, Your Honor. I think whenever a district court enjoins the president from exercising his war and foreign policy powers on bases that are manifest error, that is absolutely the sort of irreparable harm.
So, but the injunction doesn't have to be against the president. I mean, the president said, I only want people who are members of Trinidad removed. And so if his lower level executive officials are removing people who are not, or who we don't know are members of Trinidad, the problem is not with the president's proclamation, it's with its implementation by lower level executive officials. And that's against whom the TRO runs. So there's nothing there about enjoining his war or national security powers. That is all about lower level folks who are not implementing the terms of the proclamation because they're not making sure these folks are members of the gang before they remove them.
Your Honor, I disagree with that for at least two reasons. First of all, that's simply not the basis of the TRO that was appealed. If you, again, on page 41 of the Saturday transcript, you'll see the basis that the district court gave for its second TRO, and that basis was explicitly not on having anything to do with individualized determinations that people were members of TDA. It had to do with second guessing the president's determinations that there had been an invasion or predatory incursion or threatened or attempted of the same, and that
I'm not sure I've got that. 46, is that what I heard?
41 of the Saturday hearing. I mean,
The March 21st, right?
yes, Your Honor. Let me get to that specific language.
Okay.
So what the district court said in explaining why it was issuing a TRO was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA or a
I just want to make sure I'm on the same page as you. I'm looking at the afternoon transcript.
This would be the,
Oh, you know, I think I'm on the wrong transcript. That's my problem.
and
I think the transcript has line numbers, so if you could tell us the line number you're starting with. I think I have it, but just so we're all on the same page.
yes, Your Honor, it's page 41 beginning at line 12.
Sorry, that's my fault.
I'm sorry, let me pull that as well.
Really my fault.
So what the district court said was, I think they, plaintiffs, have certainly presented a serious question that the president's proclamation is not legal under the AEA, or a different way of saying it is that the AEA does not provide a basis for the president's proclamation, given that the terms invasion, predatory incursion really relate to hostile acts perpetrated by enemy nations and commensurate to war. Also, the terms nation and government do not apply to non-state actors like criminal gangs. And then he goes on without ever referencing, the opportunity to make challenges to individualized determinations under the AEA. So I think that's the order that you have before you. That's the order that we took an appeal of. And its basis is specifically the sort of second guessing of the adequacy of the president's determinations that statutory preconditions of the AEA have been satisfied. And the Supreme Court's decision in Ludecky and this court's decision in Citizens Protective League specifically preclude such review. Here's how the Supreme Court described it in Ludecky. The very nature of the president's power to order the removal of all enemy aliens rejects the notions that courts may pass judgment upon the exercise of that discretion, end quote. Similarly, this court in Citizens Protective League recognized that, quote, unreviewable power in the president, ... is the essence of the act, end quote. The binding holdings of Ludecky and Citizens Protective League are controlling precedent here. And both plaintiffs challenged the president's determination that one of the statutory preconditions there, whether there was a war that could justify invoking the act, was satisfied. In both cases, plaintiffs had very strong factual arguments. World War II had long since ended as a practical matter, and victory in Europe Day had been declared years earlier. As Justice Black noted in his dissent, the very idea that World War II was still ongoing at the time of Ludecky was, quote, pure fiction. None of that mattered, however. President Truman's determination that World War II had not ended simply was not reviewable. Federal courts therefore lacked jurisdiction to hear challenge to the president's findings that the requirements of the AEA had been met. The same result must obtain here. As in Ludecky and Citizens Protective League, plaintiffs are bringing facial challenges to the president's determination that the conditions for invoking the AEA have been satisfied. And there is no basis for concluding that the president's determination that there is a war is wholly unreviewable, but determinations that there has been an invasion or a predatory incursion or threatened or attempted of the same is somehow reviewable.
So he said, and again, I apologize, but I think this is line 10 to 11 of 41. It's outside of what Ludecky talked about. It's outside of it. And we know what was outside of what Ludecky talked about, and that was the individual determinations as to their qualification, as to whether they qualify under the order. I mean, again, there's no question that that can be done. That's been argued in this case from the beginning. It's in the complaint. It's been argued about. That's the basis on which the government keeps saying you have to do this through habeas. There's just no question that he was basing it on multiple things, and one of which, and we now have the clarification from the district court judge this morning, is that it's just about, all it has to rest on now in denying your motion to vacate is the right of them to have an opportunity, and there's no procedure as implemented by lower level officials that allows anybody an opportunity to challenge their status.
Your Honor, I simply.
The TRO rests on that. It's to the extent, I understand that there's language on both things here, but to the extent it's resting on that, and that's what we've been told this morning, and it's here as well. It's at least part of it here, and it's what's been clarified now. To the extent it's resting on that, there isn't an impermissible intrusion. It's fully consistent with our precedent in Clark and Ludicky, correct?
No, Your Honor, I simply don't agree with that. I think he told us on page 41 explicitly what his reasoning was, and I think you're reading a lot into that additional language and a whole nother holding that now exists in 37-page opinion form, but did not exist when the order was appealed and is not before you.
Well, can I ask, one of the things he said today, I just want to see if there's common ground between you and the plaintiffs and the district court. He said, before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. I think you agree with that. Do you agree with that?
I agree with part of that, Your Honor, in that he cites to a number of different cases that allow for such review in habeas proceedings. And so to the extent that someone were to bring a habeas challenge, review of some sort along those lines is.
So let me I'll use your words and then make sure that we're on the same page. To the extent that it's brought in an individualized habeas challenge, they are entitled to individualized hearing to determine whether the act applies to them at all, correct?
Your Honor, there's certainly precedent to support that. It's not precedent of the Supreme Court, so the exact contours of what a habeas court might hold are unclear, but I will certainly acknowledge there are cases that are habeas cases that exercise review, certainly of that sort. Ludicky itself exercised review over a due process challenge, and that was reviewable. It just simply had no merit whatsoever. This court itself and Citizens Protective League exercised similar review over constitutionality, but again, just thought there was no merit there.
Well, let's say that I understand you do not to be affirmatively endorsing, but not to be affirmatively contesting the statement that if they bring it in an individualized habeas petition, they're entitled to individualized hearings to determine whether the act applies to them at all. In other words, they bring a habeas petition, they can say to a federal district judge, I am not Trende Arab, and a federal district judge would review that at least to some degree. It sounds like you're not affirmatively endorsing that, but you're not arguing against it. If that is true, that they can do that, how would that work? My understanding is that in some ways it's already working. There are some individualized habeas hearings being held in Texas where the detainees are being held. So can you just help me understand? This is, I think, is a friendly question. So if they can bring a habeas petition to say, I'm not a member of TDA, so you shouldn't remove me under the president's proclamation, how would they bring that habeas claim? What would that look like?
Certainly, Your Honor. So they can bring an individualized habeas claim, and at least some arguments are certainly available in habeas. Ludicky itself reviewed a due process argument in the habeas context, so certainly at least that is available. The precise contours of that would be resolved by those habeas courts, but to your question of how would this work is how it is working in Texas right now. Courts are deciding that. How it absolutely cannot work is how the district court is.
I know that's what you think. I'm not saying I disagree with you about that. So let's say they're being held in a detention center in Texas, and they want to file a habeas petition to stop their removal under the proclamation. Would they have access to a court to do that?
They would certainly have access to a court to do so, and many have done so.
And that's important too, what you just said. Many have done so. These hearings, these habeas hearings are ongoing now, individualized habeas hearings in Texas.
That's correct, Your Honor.
Okay.
Were the people that were on the airplanes last weekend given an opportunity to file habeas?
Well, Your Honor, that we are here on a case in which the 5 individual plaintiffs were able to get in court and were able to get a TRO, and therefore were not on planes. And so they.
But one or so was on planes and got removed.
What's that? Of the 5 named plaintiffs, that's not my understanding, Your Honor. All 5, the government has represented that those 5 were not placed on planes, that the 5 that had the benefit, the individual plaintiffs that had the benefit of the first TRO who were able to get in court in time.
In this process that I'm describing, the 5 named plaintiffs here who did file in this court before they were removed from the country could have, you tell me if this is wrong, could have just as easily filed in a Texas district court a habeas petition in the district where they're being held.
Absolutely, Your Honor. And notably, in the complaint that was filed in this case, they did raise habeas action, a habeas claim. It was count 9 of it. And
they didn't just raise it. It was the title of their complaint. Their title of their complaint, I think I have it somewhere here, was class action complaint and petition for writ of habeas corpus. And they later said, plaintiffs respectfully pray this court to grant a writ of habeas corpus to plaintiffs that enjoins defendants from removing them under the Alien Enemy Act. And those are ongoing in Texas. You're saying some of those are ongoing in Texas.
Absolutely, Your Honor.
Yes, is the government detaining anyone solely on the basis of the Alien Enemy Act?
Your Honor, I would have to check that specifically. Almost everyone is being detained additionally under Title 8. I'm not sure if there are any specific AEA only detentions. Certainly, but the challenge has been brought to that.
I'd be curious to know if you can find out and if it wouldn't reveal, something too sensitive to reveal. If there's anyone being detained solely on the basis of the Alien Enemies Act.
Your Honor, we're certainly happy to track that down and provide that information to the court.
Thanks.
Mm-hmm.
And
It seems like the relevant thing is were people being removed solely, not detained, but removed solely based on the proclamation. It seemed like, again, you can clarify for me, I'm just looking at a cold record here, that the proclamation was signed and people were getting put on planes immediately without even notice as to the basis, let alone an opportunity to file suit. And so were those removals, I think there was one airplane that you said that was people were removed on other grounds, but there were 2 where the government hasn't argued that. Am I recalling the record correctly?
Your Honor, I believe so. I mean,
2 planes worth of people removed under the AEA, not under withholding of removal process, or removal of the ordinary INA removal.
The Title 8 process. Yes, Your Honor. But I think the fact is that 5 individual plaintiffs were able to march into court, file habeas, actually get relief, admittedly on non-habeas grounds. And the fact that opportunity.
Without the government, that was a super fast order that was done, as you know. The government was called and notified, and then a hearing that afternoon. But that's one of the reasons there's all these separate disputes in district court about compliance, because planes were already loaded and taken off. And those folks did not have notice or an opportunity to challenge their status at all. And that's why there's had to be a class certification to slow things down until we have an opportunity for due process.
Your Honor, I think this court's decision in IM versus CBP is instructive on this.
Am I wrong about anything I just said factually?
Your Honor, I think it's incorrect that they couldn't have gone into court as the 5 individual plaintiffs.
No, but the point here was that there were plane loads of people. It's a class action. There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations and they had hearing boards before people were removed. And yet here, there's nothing in there about hearing boards, there's no regulations, and nothing was adopted by the agency officials that were administering this. People weren't given notice, they weren't told where they were going, and they were given, those people on those planes on that Saturday had no opportunity to file habeas or any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes, people were removed under the AEA. What's factually wrong about what I said?
Well, Your Honor, we certainly dispute the Nazi analogy, but more importantly, the fact is that individual plaintiffs were able to file habeas in time in order to secure relief.
Wait,
And
what
this court-
individual plaintiffs were?
The 5 individual plaintiffs that
That's not my question. My question is there were a lot more people. They wanted to bring a class action. They had to have some named plaintiffs. So 5 people filing habeas doesn't help everybody else on 2 airplane loads. Correct? And my question to you is, and you said those 5 didn't get put on the airplanes. So as to the 2 airplanes that I think you just agreed involved removals solely on AEA grounds, on Saturday, the very short time of the proclamation's publication, had no opportunity to file for habeas or even notice as to the grounds on which they were being removed. Am I wrong about that?
I think so, Your Honor. The fact that 5 individual plaintiffs did file habeas and did get relief indicates that they could.
I don't think you're answering my question. My question is not as to the 5 plaintiffs. How much time, I want you to think of 5 other people on the first airplane. How much time when were they given notice that they were being removed under the AEA on the grounds that they were members of Tren de Aragua? And how much time were they given between that notice and being put on the airplane that Saturday, right after the proclamation was signed, to file a suit?
Your Honor, those facts are not in the record, and I don't know all of them offhand, but I think.
Okay, so go ahead, you think?
But I think the fact that 5 individuals were able to do so indicates that others could have. Well,
They didn't. They filed suit before the proclamation was even published. I've asked you after the proclamation was published. And I assume these habeas actions that you're talking about, and correct me if I'm wrong, that are now being filed in Texas, have been filed since there's been a stay.
But Your Honor, I'm talking about
Right?
the 5 individual plaintiffs in this case.
That's not my question.
I understand.
The question here is, if someone thinks there was a meaningful opportunity, notice and opportunity to file for habeas for the people on those 2 airplanes, which are not these 5 named plaintiffs, because they filed before the proclamation was even published. If there was no opportunity for those folks to file habeas, then that's the issue for the TRO, to freeze things in place so that compliance with due process can occur.
Well, Your Honor, as to due process,
You haven't disagreed with any of my facts about there wasn't time for the people on those 2 airplanes. You haven't asked.
Your Honor,
One at a time. Were they given notice before being put on the airplane that they were being removed because they were members of Tren de Aragua pursuant to the President's proclamation under the AEA?
Your Honor, I don't think that is in the record.
You can't speak for the government with knowledge about that.
Your Honor, my understanding on public news reports is that they had some sort of notice. I don't know the specific contours of that, but again,
Okay.
our position is that
So there's no record that they were given notice. And then how much time was there between the President's signing of the proclamation and those 2 planes taking off?
Your Honor, that's not in the record. I don't know that
But you had the times of those planes down pretty clearly, and we know what time the President's proclamation was published.
Your Honor, the record has what times that they had departed before the 7:25 p.m.
That must be findable. What time the planes took off.
Your Honor, it's that is currently, the government is currently engaged in evaluating if any of that can be disclosed.
What time, you can tell what time the planes landed, but you can't tell what time they took off?
We have told what time what their status as of when the 7:25 p.m. minute order issued. and I'm not authorized to discuss any more operational details than
Is
that.
the government aware of how long it takes to fly from wherever this airport is in Texas to El Salvador generally?
Your Honor, I don't know that off the top of my head.
And that can be found out pretty easily.
I'm-
Time. I mean, it just feels like there was no time. And the habeas cases you're talking about now were only able to be filed because the district court froze things.
Well, Your Honor, this case itself was originally filed as a
Are there
habeas action.
other habeas cases that you mentioned filed in Texas? When were they filed?
Your Honor, at least I believe at least one of them was filed, but before the plaintiffs indicated that they thought the plane had taken off. That I can track down, but that's my recollection.
The other ones have all been because there's a stay in place.
What's that? You know, I don't know the precise status of every single one of those individual habeas actions. That's very
They
fast.
could have been filed before the president's proclamation was made public, and before someone was told that they were being subject to it, right?
Your Honor, again, I just
Because
disagree.
it wouldn't be a right claim.
Your Honor, we're here because 5 individual plaintiffs filed a complaint that clearly included habeas claims, as Judge Walker indicated, and here we are hearing that very claim. And here's what this court said, in IAM versus CPP. IAM contends that a removed alien may file a habeas petition if extreme circumstances prevented him from filing while he was in custody. We disagree. Lower courts are created by Congress and have only the jurisdiction Congress grants, no more, no less. And, you know, Your Honor indicated that you thought that this was a matter of due process, but I think that's very useful here because the Supreme Court and this court have confronted due process claims challenging the invocation of the AEA. And, you know, here's what Supreme Court said in Ludecky. It said, the act is almost as old as the Constitution, and it would savor of doctrinaire audacity now to find the statute offensive to some emanation of the Bill of Rights, which obviously includes
I'm not saying the whole statute's unconstitutional. No one's saying the Alien Enemies Act is, well, maybe they'll tell me they're saying that, but the entire Alien Enemies Act is unconstitutional. That has been decided. The question is whether a particular proclamation and its implementation is constitutional. This happens all the time. The statutes are constitutional, but how they're implemented in a particular case is not. That's all we're talking about. And in Ludecky and in Clark was a case like this one. It wasn't a habeas, sorry. I used a shorter name for the case in this court, Clark. It was 159 people and an organization who represented their interests who filed suit. And we recognize there that you could have a challenge to whether you qualify under the proclamation, right?
Your Honor, I don't think.
That's the issue here, is whether there's a process.
I agree that that's how the district court saw it, but there were due process arguments raised in those cases as well. And you know, this court said that if there was the slightest question in the minds of the authors of the Constitution or contemporaries concerning the constitutionality of the Alien Enemies Act, it would have appeared. None did.
Yeah, that's the constitutionality of the act. You just finished the sentence for me. My question is, and I think what district court here hasn't called into question the constitutionality of the Alien Enemies Act. It's been upheld, as you said, as a part of the war power. But so that's not the question here. The question is whether the implementation of this proclamation without any process to determine whether people qualify under it. I mean, if the government says we don't have to give process for that, then y'all could have put me up on Saturday and thrown me on a plane, thinking I'm a member of Nicaragua and giving me no chance to protest it and say somehow it's a violation of presidential war powers for me to say, excuse me, no, I'm not. I'd like a hearing. You wouldn't say that.
Your Honor, obviously nothing of the sort is presented by the record here. I think what.
No, we don't have any record on whether these individuals are members of Nicaragua or victims of Nicaragua.
Your Honor, as you've characterized it, what that sounds like to me is an argument that the AEA is unconstitutional because it doesn't provide for pre-deprivation.
It's not an argument about the statute. I'm going to say this, and I don't know how to say it any more clearly. My questions are about the implementation of a particular proclamation under the statute. That is not an argument. And quite frankly, the statute provides that there will be regulations issued. And regulations to determine someone's status have happened every other time the statute's been used. So this isn't about the statute being unconstitutional, it's whether implementation of it under this proclamation is unconstitutional. And not even, is it unconstitutional? Is there a likelihood of showing that there's a constitutional problem here because of the lack of due process? We're not even deciding the merits. So please do not attribute to me that I'm saying the statute's unconstitutional. You and I agree that that has been answered. But implementation of a proclamation is a completely different question. Can we agree on that?
Your Honor,
You won't agree, I mean, maybe that it's constitutional problem, but you agree that it's a separate question whether the implementation of something under a lawful statute is constitutional.
Your Honor, certainly at that level of abstraction, I agree with you. I see that.
Drill down exactly what this case is. That's not abstract.
Well, Your Honor, where I disagree is that, as Your Honor identified, the AEA requires the issuance of regulations. It does not require the provision of pre-deprivation process. And so I think that would be an argument that under the Due Process Clause, the failure to provide of the AEA itself to mandate pre-deprivation hearings is unconstitutional. And I think that is the sort of challenge that was considered and rejected.
When were other usages of the AEA done and people were summarily removed without advanced process? Can you show me an example in history when the AEA was used that way?
Yes, Your Honor. So in Ludecky, for example, there was a requirement in the implementing regulations that that an alien had to be dangerous before that they would be removed, and there was part of the challenge was that that person was not dangerous, and wanted to challenge the Attorney General's determination that he was, and what the Supreme Court said. Is that President Truman, provided for the removal of such aliens as were deemed by the Attorney General to be dangerous, that such a finding at the President's behalf was likewise not to be subjected to the scrutiny of...
A different question. All right, footnote 5. The order recited that the petitioner was deemed dangerous on the basis of evidence adduced in hearings before the Alien Enemy Hearing Board.
That's what I'm talking about. They had a process there for the decision. Question whether a court can review whether a secretary properly deemed someone dangerous. That's what they said. That's committed to the discretion of the secretary whether someone's deemed dangerous. But there was hearings and there was process. I asked you when they haven't had process.
Your Honor, I guess then that points to me that this conversation has been very much about due process, but even as the 37-page opinion that issued this morning, it seems to sound in due process, but doesn't make a holding based in due process. And so that alone...
Well, it says it's limits, that's how, it's not holding because it's a TRO, but it says it's limiting its likelihood of success analysis to that question. And then to get, if you want to respond to that, because I wanted to get to this question of whether it can only go through a habeas, but I wanted to let you.
Your Honor, so, we think that the rationale has been swapped out at the last minute, less than 4 hours before oral argument. We think that's procedurally improper and potentially jurisdictionally problematic, where the ordinary rules of jurisdiction do not permit district courts to present this court with a moving target on appellate review, and I think that's exactly what we have here.
Another procedural problem here is that you never sought a stay from the district court.
That's correct, Your Honor. This is obviously
You've had plenty of time. You've had a week, more than a week. You've never sought a stay from the district court first, which our precedent require.
No, Your Honor, certainly that is a general thing. This case is absolutely extraordinary that we moved within mere hours for this court. It obviously was not possible to exhaust before the district court in that time.
Before the court, I don't mean you personally, the government was before the court Saturday afternoon in person when the TRO issued, right? There was a government attorney, I don't know if it was you or someone else, but there was a government attorney before the court Saturday afternoon when the operative TRO now was issued, correct?
That's correct, Your Honor, although...
An attorney have said when the TRO was entered, we request a stay so we can seek relief from the Court of Appeals? Did they have time to do that at that hearing?
I suppose so, Your Honor, although
Take a stay.
Your Honor, a couple things let me say about that. First of all, that TRO, it was scheduled as a hearing for class certification that the government was surprised to discover, and I was personally just surprised to discover that the TRO merits would be discussed. The hearing was only set for class certification, and on that question of class certification, the government was not permitted to file even a single sentence of written briefing in opposition before we were hauled into court on a Saturday at 5 p.m. and a nationwide class action or class was certified. And then in that posture, we were then surprised to discover that notwithstanding the fact that the that the notice was for a hearing on class certification, that in fact a second TRO would be, the merits of which would be considered, that was presented there. We certainly believe that it wasn't.
I don't understand how that means you didn't have time that afternoon, or Sunday, or Monday, or Tuesday, or Wednesday, or Thursday, or Friday, or Saturday, or Sunday, or this morning. That's the first day from the district court. You've had time, correct?
Your Honor,
We've had time, yes or no?
We've had time. It's clear that we went to this court. Your Honor, certainly too, this is not, I believe, an issue, the FRAP 8 compliance that plaintiffs have raised. So it's by itself may have been forfeited because that is not an argument that I believe that plaintiffs have raised. But